In the year 1666, London was enveloped by the Black Plague and the Great Fires. During this chaotic time, Parliament enacted a significant law behind closed doors, known as the Cestui Que Vie Act of 1666. This act subrogated the rights of men and women, essentially declaring all men and women as dead, lost at sea or beyond the sea. At that time, operating under Admiralty law, the law of the sea, being lost at sea, had significant legal implications. Consequently, the State of London took custody of everyone and their property into a trust. The state became the trustee or husband, holding all titles to the people and property until a living man or woman comes back to reclaim those titles, at which point they can also claim damages. When you see capital letters used in a name, this always refers to a legal entity or fiction, such as a company or corporation, with no exceptions. For example, John Doe or Doe Jane. In New Zealand and Australia, this is commonly referred to as Cestui Que Trust, pronounced Cestui, and in the United States of America or Canada, it's known as straw man. These terms describe the legal entity or fiction created and owned by the government that created it. It's akin to owning a share in the stock market. You may own a share, but it remains just a part of the whole stock. Legally, we are considered to be a fiction, a concept or idea expressed as a name, a symbol. This legal person has no consciousness. It is a juristic person, ens legis, merely a name or word written on a piece of paper. Our only way out is to reclaim your dead entity, the straw man that the Crown created, become the executor, and then collapse the called Cestui Que Vie Trust and forgive yourself of your debts. Then, you must remove yourself from the Admiralty law that holds you in custody. When London burned, the subrogation of men's and women's rights occurred. The Responsible Act, the CQV Act of 1666, declared all men and women of the UK dead and lost beyond the seas. The state took everybody and everybody's property into trust. The state maintains control until a living man or woman comes back and claims their titles by proving they are alive, and claims for damages can be made. This is why you always need representation when involved in legal matters, because in the eyes of the law, you're dead. The legal fiction is a construct on paper, an estate in trust. When you receive a bill or summons from court, it is always in capital letters, similar to tombstones in graveyards. These capital letters signify death. They are writing to the dead legal fiction. All this information relates to how the general public are still legally tied through maritime admiralty law. Through this ancient legal construct, we can be easily controlled and duped. Learning about your legal fiction helps you to unlock yourself. Otherwise, you are just an empty vessel floating on the sea of commerce. Parents are tricked into registering the birth of their babies. In about 1837, the Births, Deaths and Marriages Act was formed in the UK, and the post of Registrar General was established. His job was to collect all the data from the churches which held the records of birth, regis from Queen or Crown. All people are seen to be in custody of the Crown. This allows people to function in commerce and to accept the benefits provided by the state. We have to understand who we are as men and women and how we can relate in the system. A Cestui Que Vie Trust, also known later as a Fide Commissary Trust and later again as a Foreign Situs Trust, and also known as a form of secret trust, is a fictional concept being a temporary testamentary trust, first created during the reign of Henry VIII of England through the Cestui Que Vie Act of 1540 and updated by Charles II through the Cestui Que Vie Act of 1666, wherein an estate may be effected for the benefit of one or more persons presumed lost or abandoned at sea, and therefore presumed dead after 7 years. Additional presumptions by which such a trust may be formed were added in later statutes to include bankrupts, minors, incompetents, mortgages and private companies. The original purpose and function of a Cestui Que Vie Trust was to form a temporary estate for the benefit of another, because some event, state of affairs or condition prevented them from claiming their status as living, competent and present before a competent authority. Therefore, any claims, history, statutes, or arguments that deviate in terms of the origin and function of a Cestui Que Vie trust as pronounced by these canons is false and automatically null and void. Since 1933, when a child is born in a state estate under inferior Roman law, 3 Cestui Que Vie trusts are created upon certain presumptions, specifically designed to deny the child forever any rights of real property, any rights as a free person, and any rights to be known as man and woman rather than a creature or animal, by claiming and possessing their soul or spirit. Since 1933, when a child is born, the executors or administrators of the higher estate knowingly and willingly claim the baby as chattel to the estate. The slave baby contract is then created by honouring the ancient tradition of either having the ink impression of the feet of the baby onto the live birth record, or a drop of its blood, as well as tricking the parents into signing the baby away through the deceitful legal meanings on the live birth record. This live birth record, as a promissory note, is converted into a slave bond, sold to the private reserve bank of the estate, and then conveyed into a second and separate Cestui Que Vie trust per child owned by the bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property, and itself monetized as currency issued in series against the Cestui Que Vie trust. The 3 Cestui Que Vie trusts are the specific denial of rights of real property, personal property, and ecclesiastical property for most men and women, corresponds exactly to the 3 forms of law available to the gala of the Bar Association courts. The first form of law is corporate commercial law, is effective because of the first Cestui Que Vie trust. The second form of law is maritime, and trust law is effective because of the second Cestui Que Vie trust. The third form of law is Talmudic, and Roman cult law is effective because of the third Cestui Que Vie trust of baptism. The birth certificate issued under Roman law represents the modern equivalent to the settlement certificates of the 17th century, and signifies the holder as a pauper and effectively a Roman slave. The birth certificate has no direct relationship to the private secret trusts controlled by the private banking network, nor can it be used to force the administration of a state or nation to divulge the existence of these secret trusts. As the Cestui Que Vie trusts are created as private secret trusts on multiple presumptions, including the ongoing bankruptcy of certain national states, they remain the claimed private property of the Roman cult banks, and therefore cannot be directly claimed or used. While the private secret trusts of the private central banks cannot be directly addressed, they are still formed on certain presumptions of law, including claimed ownership of the name, the body, the mind and soul of infants, men and women. Each and every man and woman has the absolute right to rebuke and reject such false presumptions as a holder of their own title. Given the private secret trusts of the private central banks are created on false presumptions, when a man or woman makes clear their live-born record and claim over their own name, body, mind and soul, any such trust based on such false presumptions ceases to have any property.